Two of the most high-profile criminal cases are coming to an end, but for very different reasons. Today, while everyone waits to learn the fate of hip-hop icon Sean Diddy Combs, we're diving into the questions being raised by the jury as they work their way to a verdict. And we're going to pull back the curtain on the bombshell plea deal that was just revealed in the Bryan Kohberger murder case. All this today on Crime and Justice with Loni Coombs. First is day 2 of jury deliberations in the Sean Combs trial. The rapper is facing 5 federal charges, including sex trafficking and racketeering conspiracy. And the jury is keeping the judge and the attorneys on their toes with several questions. What are they asking? And what do their questions indicate about where they are in their deliberations? Combs is facing serious prison time here, potential life in prison if convicted of the racketeering charge. He's remained composed in the court. He's actually been seen reading 2 books while he waits for the jury. And if you're curious about his reading list, the books were The Power of Positive Thinking by Norman Vincent Peale and The Happiness Advantage by Shawn Achor. I've asked a good friend of mine to join our discussion here. Mark Eiglarsh is an experienced defense attorney as well as a very seasoned TV legal analyst. Mark, it is great to see you today. Thanks so much for being here.
I'm grateful for the opportunity. Thank you. Great to see you.
All right, let's dive into what's going on with the Sean Combs jury. So yesterday, they had 2 questions for the judge. The first one came out just about 1 hour into their deliberations, and it said, we have a juror, number 25, who we are concerned cannot follow your honor's instructions. Now, this juror, which, Mark, they didn't hesitate to specifically identify, is a 51-year-old Manhattan scientist with a doctorate in molecular biology. So it doesn't seem like they were referring to a lack of ability to follow the instructions. Then the judge sent back his own note telling the jury that it was their duty to follow the instructions and to continue deliberating. So what in the world do you think was going on back in that jury room that prompted that question to the judge?
Oh, I think it happens in every household, every bar, people who don't like other people. And that's what happened here. The guy didn't like the treatment he was getting, and he wasn't playing nicely with the others. I called this at the time when I was literally on air, and they fed this to us, and I said, this is colossal. As a defense lawyer, this is what you want. Yeah. You don't want a unanimous verdict. So when there's dissension, to the extent that the foreperson is saying, Daddy, he's not playing nicely with the others, we need help. And Daddy says, no, you go work it out on your own. That's huge.
Yeah. Not only that, but it's just 1 hour into the deliberations, right, Mark? I mean, I think we've all gotten some of these notes sometimes, but it's usually like a couple days. This was literally 1 hour. They were already not getting along. Yeah.
Right.
All right. Okay. At the end of that day, a second note came out to the jury. They were asking the judge to clarify whether merely giving drugs to someone who asked for them constitutes a crime of distribution. Now, this is clearly referred to as it's clearly referring to one of the predicate crimes, right, that's listed under the racketeering charge. So the judge responded by referring the jury to that specific instruction on distribution of narcotics, which says that that description they gave did indeed qualify for the crime. No sale is actually needed. So as a defense attorney, Mark, how are you feeling when you hear that question come from the jury?
Well, just so the viewers are clear, the judge didn't say, let me direct you to the place in the law where that does qualify. He couldn't say that, or else this would be a reversal on appeal. What he said was, take a look at this law. You mean the law they already heard, the law that couldn't resolve this issue without judge intervention? This is, again, another wonderful thing for the defense, because it was like a softball. Clearly, he gave out drugs to numerous people, and apparently they're not clear if that fits the definition. Once again, potential insight into reasonable doubt.
You know, so interesting you say that was good for the defense, because a lot of people for the prosecution side said, hey, this is great. They're looking at those predicate crimes. It's clear that the question they're asking does qualify as one of those predicate crimes. So they just got confirmation from the judge. It looks like that's a slam dunk for at least that one predicate charge.
I don't see it that way. I look at everything from the defense lens, and unless it's crystal clear, favorable for the government, any ounce of dissension, any unclarity clearly goes to the defense.
And that's why it's always so hard to try and speculate as to what the jury is actually thinking, right? Because we see it through our own lenses. Right. All right, so today, that's right. So today, Mark, the jury asked the court for several parts of testimony from Cassie Ventura. Now, she's the prosecution's star witness. Remember, she came in, she was very pregnant. She was on the stand for days. People thought it was very emotional, very compelling testimony. But now they're asking for a lot of that to be read back, as well as one of the male escorts who testified to participating in freak-offs with her. So it seems like the jury is being very meticulous in its analysis here. But I want to hear your evaluation as a defense attorney.
Well, you don't go back and ask for testimony to be read to the jury unless there's a question that came up in the jury room. So I'm guessing somebody said, well, Cassie said this. Well, hold on one second. That's not what I heard. And they tried to go around and clarify. Maybe somebody took some notes. I don't know if he let them take notes. If not, they go, well, let's just get this read back. Yeah. Again, I think there's some disagreement on what the facts are. And she's a critical witness. You've got to determine whether this is rape or regret. Mm. And how do you do that? You discuss it.
Yeah. And she was right at the beginning of the trial. So that's weeks ago. It's helpful if hopefully they'll be able to read those transcripts. All right. Meanwhile, we're going to turn to some shocking news that we heard just yesterday. A guilty plea from accused Idaho murderer Bryan Kohberger. Now, this is the highly anticipated multiple murder trial that was supposed to begin jury selection at the beginning of August, just a few weeks away. But instead, it's abruptly ending. This former criminology student who's accused of murdering 4 University of Idaho students by stabbing them to death back in 2022 has been offered a plea deal by prosecutors, and Kohberger has accepted that deal. Now, under the terms of this plea deal, Kohberger will plead guilty to all the charges, as well as waive his right to appeal. And in exchange, he'll be spared the death penalty. Instead, he'll be sentenced to 4 consecutive life sentences. Now, this deal has ignited strong reactions from the victims' families, who found out about this deal through a letter from the prosecutors. That letter read, quote, "We cannot fathom the toll that this case has taken on your family. This resolution is our sincere attempt to seek justice for your family. This agreement ensures that the defendant will be convicted, will spend the rest of his life in prison, and will not be able to put you and the other families through the uncertainty of decades of post-conviction appeals." So, Mark, let's turn to this plea deal here for Bryan. Mixed reactions to it from the families. Kaylee Goncalves' father spoke out about it. On a Facebook post last night, he said, quote, "We are beyond furious at the state of Idaho. They have failed us. Please give us some time. This was very unexpected." Meanwhile, Maddie Mogan's father told CBS News that the plea deal actually allows them to put this behind them and not have future dates and future things that they don't want to have to be at that have to do with this terrible person. You know, Mark, in my 20 years as a prosecutor, I worked with many, many victims and their family members, and I would always, at the very least, try to let the family know ahead of time what I was doing and why. Here, they just learned it by a letter, right? So why do you think the prosecutor handled it this way?
Okay, you just raised so many issues. Rookie prosecutors, back when I was, 33 years ago, on DUI cases, you wouldn't work out a fender bender without getting the victim's approval. You learn that. That's prosecution 101. That's the only way you really get in trouble. This case, I think that what they did was reprehensible. We're not talking about the actual deal itself, which I think might have some merits on both sides. I'm okay with how they actually, resolve this the way that they did. I'm concerned about the way they blindsided the victim's family. You don't do that. Why did they do it? I don't know. Political suicide, causing them additional trauma that they didn't need. There is no excuse for handling it the way they did. Them disagreeing with the outcome, that's understandable. But that's different than blindsiding them, Loni.
Yeah, I really agree with you on this one. You don't necessarily have to get their approval. They don't necessarily have to sign off on it. But the very least that you can do to dignify them as, the victims' families here is to let them know what's going on. So we don't know why the prosecutor, right, decided to make this offer all of a sudden. They've been adamant about going to trial, and they have been fighting to keep the death penalty. And now all of a sudden they've just, let it go away. So it could be.
I'll tell you why.
Go ahead.
I'll tell you why. Loni, because as you know, and we have many examples of it, first of all, a guilty verdict is not a slam dunk. People can talk all you want. Well, there's DNA on the sheath. All right, well, then the defense would have manufactured. They would have said something. They would have said, okay, and I'll just throw out something. They had a lot of parties at that house. We know that because there's body cam footage of police coming to the house. He then would have claimed he was at the house a number of times. His DNA then is inside the house, and the sheath, because of transfer DNA, got his DNA on there. I don't know if there's any value to that, and I don't know if there's anybody who would support that, but there's no slam dunk in a jury trial. Secondly, and most significantly, we know that it's hard to get the death penalty. In Idaho, all 12 jurors must be unanimous. One juror hears, oh, okay, he's autistic. Yeah, my son's autistic. Oh, I can relate to that. I don't want to kill my son. He's like my son. It takes one juror, then they're done. And not to mention, even if there is a conviction, possible appeals down the road, possible reversals, hung jury. There's so many benefits, not to mention the cost, which is easily 5 to 6 times more to actually kill someone than to put them in prison for life. There's many reasons. I'm not necessarily advocating for it. I'm saying I understand why the prosecution did what they did.
And that's exactly what I think the victims deserve to hear, is exactly what you just laid out, so they can understand why this might have happened. You know, but Mark, here, there are some big questions in this case that we just don't know the answers to, like, what was the connection between the defendant and these victims? What was his motive? Where's the knife? Now, if I'd been the prosecutor negotiating this plea, I would have insisted on getting those answers before they agreed to the deal. The families may never get the answers now.
It would have been nice, but most families don't ever get the answers, which is why prosecutors don't have to prove motive. Because how about he's just a sociopath, jerk, an abhorrent, disgusting, defective human being? You'll never get the answer, and the answers won't bring you, peace and closure, So rarely do you ever get the true answers to anything.
You know, Mark, some of the family members have actually said that they're going to go tomorrow to this hearing, because it's set for a hearing tomorrow. They're going to ask the judge to reject this plea bargain here, right? Because both sides will bring it to the judge, and then the judge has to decide. Do you think the judge should?
Well, I thought you were going to say, will he do it? And should he do it? No, number one, I don't think he should. I think that this was not on a whim. This case has been around for 2.5 years. Prosecutors gave it a lot of thought. The defense gave it a lot of thought, and they came up with a fair resolution. Successful negotiations are when both parties walk away from the table not getting exactly what they want. I think both parties are doing that, and they're sparing everybody the emotional and financial turmoil of what would be at least one trial, and maybe more if it was reversed on appeal. Do I think the judge is going to disturb that? Absolutely not.
All right, I want to ask you, Mark, I want you to step back a little bit. You know, you do a lot of not only in the courtroom, which I really appreciate because you've got real trial experience, but you also are a very experienced TV analyst, right? So you've been watching over these years how the true crime focus, some people call it obsession, has really evolved. And now this was a highly anticipated trial, right? And as true crime and trial watching increasingly becomes almost, I don't want to say it's a form of entertainment, but literally some people plan their vacations around traveling to courtrooms and trying to get inside for a firsthand view. And some people seem to be very disappointed, right, that this one isn't playing out. Just like they were disappointed that in the Diddy case, there weren't cameras in the courtroom. Do you think this evolution of such a focus on these trials helps or hurts the process?
Good question. As long as justice still prevails and people aren't interfering with cases being treated properly, then I'm okay. Where it starts to get a little bizarre was, like, for example, in the Menendez case, putting aside your feelings for them finally getting out, the bigger issue is there's hundreds of thousands of Menendez brothers in prisons who committed offenses at young ages, who didn't have the Kardashians advocating for their release or didn't have a Netflix special about them. So really, we're now going to give attention and focus on justice for those where the most popular cases are. That concerns me, right? So other than that, I guess as long as it doesn't interfere with justice, then they can have a front row seat and watch what happens. Yeah,
and I do think there's advantages. You know, when I was in the DA's office, it used to make me very anxious because it was just starting to, have cameras in the focus. But I do think that a spotlight on it does help everyone make sure that they step up and act the way they're supposed to, hopefully. But there's always that interference,
like you said. I'll defer to you then. I'll go along with what you said. You're smart.
But I agree with you. I think that interference can end up being a negative thing if we're not careful in the long run. Mark Eiglarsh, I so appreciate your experience and your insight into these trials. You're always so good, right on top of it. Thanks so much for being here.
Thanks for having me, Loni. I appreciate all that you do. Thanks.
Thank you. And please subscribe to get all the latest updates here on Crime and Justice. I'm Loni Coombs. I'll see you tomorrow.